Your business partner stops showing up, or worse, they're actively damaging the company. So you do what feels natural. You try to fire them. And that's when a Florida lawyer tells you the sentence that stops business owners cold. You can't. In Florida, a member of an LLC is not an employee. You can fire an employee on a Tuesday afternoon, but a member owns the company with you. And if you never signed an operating agreement, Florida law just locked the two of you in the same room. I call it the partnership prison. And today, I'm showing you the 3 doors out and why 2 of them run straight through a courtroom. All right, let's dive into this one. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. Now, I've handled member disputes and business divorce cases across this state over the past 3 decades. And the reason this video exists is simple. Every week, someone sits in my office convinced they can vote their partner out. And here's what the law actually says. Florida LLCs are governed by Chapter 605 of the Florida Statutes, the Florida Revised Limited Liability Company Act. It's a mouthful, but you better pay attention. When you skip the operating agreement, Chapter 605's default rules take over automatically. You never voted for them. You probably never even read them, but they control your company. And here's what those default rules do not give you. They do not give you a right to expel a member just because they're lazy. They do not give you a right to expel a member because you can't stand them anymore. They do not give you the right to expel a member because the business would be better off without them. And you're probably thinking, that's insane. I own the majority. I should be able to remove them anytime I want to. Actually, your ownership percentage doesn't matter here. Membership in a Florida LLC is a property right. The state does not let you take someone's property by vote. That's the partnership prison. 2 owners, 1 company, no exit clause. But here's the thing. The law didn't leave you with 0 options. It left you with actually 3. And the first one is the only one that doesn't require a judge. Door 1 is a negotiated buyout. You sit down with your partner, usually with lawyers in the room, and you purchase their membership interest. Price, payment terms, releases, non-competes, all of it in writing. This is the door I push clients towards first because it's the fastest and the cheapest. And the reason why is leverage. When your partner learns that doors 2 and 3 actually look like a reasonable buyout number starts sounding very good. Now, a warning sign before we move on. Stop assuming that if your partner simply walks away, the problem solves itself. It doesn't. Under Chapter 605, a member who leaves, and what the statute calls dissolution, generally keeps their economic rights. I call this the ghost member rule. They lose their value, they lose their management role, but they keep collecting their share of the profits as a transferee. Florida law does not force an automatic buyout when a member exists. So your departed partner can haunt your distributions for years. Now, the ghost member rule is the single biggest surprise in these cases, and that is exactly why the next 2 doors exist. Door 2 is judicial expulsion. Chapter 605 lets the company or another member ask a Florida court to expel a member by court order. But you don't get this remedy just because the partnership went sour. You have to prove grounds. The statute recognizes situations like a member engaging in wrongful conduct that adversely and materially affected the company's business, a member willfully and persistently breaching the operating agreement or their duties to the company, or a member whose conduct makes it not reasonably practical to carry on the business with that person. Notice the pattern: misconduct, breach, impossibility. Not laziness, not personality conflict, not we grew apart. When your partner is stealing from the company, competing against it, or sabotaging it, judicial expulsion is your weapon. And when they're just difficult, the court will tell you that's the business you chose. And quickly here, if you're getting value from this breakdown, hit like and subscribe, because here's where it gets interesting. The 3rd door is the one nobody wants to open, but it's also the one with the hidden off-ramp most owners have never even heard of. Door 3 is judicial dissolution. I call it the nuclear option because instead of removing the member, you ask the court to kill the company. Chapter 605 allows a member to petition for dissolution when, among other grounds, the manager or members are deadlocked and the company is suffering, or when it's no longer reasonably practicable to carry on the business in line with the company's governing documents. 50-50 owners who can't agree on anything, that's the classic deadlock case. The court appoints a process. The assets get liquidated, creditors get paid, and whatever's left gets split. And you're probably thinking, well, why would I ever burn down my own company? Well, here's the answer. Sometimes the credible threat of dissolution is the only thing that brings a stubborn partner to the table. And sometimes the company genuinely cannot survive the war. But here's the off-ramp I talked about earlier. Chapter 605 builds in a pressure valve. When a member petitions for dissolution, the company or the other members can elect to purchase that member's interest at fair market value instead of letting the company die. Now, the dissolution case converts into a valuation fight. Now, I call this the buyout off-ramp. The company survives, one owner leaves with a court-supervised check, and for a lot of my clients, this is the real endgame. Dissolution is the threat. The buyout is the result. Now step back and look at what all three doors have in common. Every single one is slower, uglier, and more expensive than one document would have been. An operating agreement with expulsion triggers, buyout terms, and evaluation formula turns a 2-year lawsuit into a 60-day transaction. The reason member removal cases keep Florida litigators busy is that thousands of owners file on sunbiz.org, get their certificate, and never write the one document the state never asked them for. Don't be the next case study. When your LLC has more than one member and no operating agreement, fixing that is the most valuable legal money you'll ever spend. So here's your map out of the partnership prison. Door 1, negotiate the buyout. Always try this one first. Door 2, judicial expulsion, when there's a real misconduct. Door 3, judicial dissolution, with the buyout off-ramp waiting inside it. And watch out for the ghost member rule, because a partner who walks away hasn't actually let go of your profits. Now, if this video helped you understand your options, hit that like button and subscribe. I break down Florida business law so you can protect yourself before the dispute, not after. I'm Santiago Cueto, your Florida business attorney. Now watch this next video. It's a masterclass on litigation strategy. I'll show you how to weigh the financial and operational costs of setting internally versus engaging in a full-blown corporate trial.